Welcome to the Case Bank 7-minute update featuring 13 of the 61 new summaries added to the database during December 2020. The first 4 cases this month come from the California Supreme Court. Case 1. Defendant solicits undercover officer to be a prostitute for him after the officer tells the defendant she is age 17. The officer is actually over 21. Held. This is a direct violation of PC 236.1c sub 1, attempt human trafficking. There is no need to resort to PC 664 for an attempt charge. Case 2. Senate Bill 1437 does not apply to cases on appeal at the time of enactment. The procedures under PC 1170.95 are the sole means of applying SB 1437 to old cases. Case 3. Eligibility for possible early parole under Prop 57 is determined solely on the defendant's current convictions, not all of the defendant's past convictions. Case 4. Department of Correction regulations implementing Prop 57 rate eligibility for possible early parole excluded nonviolent 290 registrants. Held. Prop 57 did not authorize such an exception. Prop 57 applies to all nonviolent offenders. Case 5. Entire event was recorded by 4 video cameras, 3 officer body cameras, and 1 security camera. Therefore, officer credibility is not at issue. Therefore, no basis for a Pitches motion. Case 6. Minors have a statutory right to be physically present in court during any hearing under Welfare and Institutions Code Section 679. Statewide COVID emergency rules say minor must consent to appear via Zoom. Local rule saying minor has burden to show why Zoom is inadequate is vacated by the DCA. Case 7. Passenger in defendant's car is on probation with search terms. Police see the passenger leave the car as they approach. Once police learn of passenger's search terms, they can search the passenger area of the defendant's car, including the glove box. Case 8. While crime X may be a general intent crime, conspiracy to commit X or aiding and abetting X requires specific intent. Therefore, although mistake of law is not a defense to X, it might be a defense to conspiracy to commit X and/or aiding and abetting X. Case 9. If possessed by the right person with the right motivations and intents, a common ordinary box cutter can qualify as a dirk or dagger under Penal Code Section 21-310. Case 10. Defendant enters into a plea bargain for a set number of years that included conviction and sentence on a 1 year prior under PC 667.5b. After sentencing, statute change made the prior invalid. Held. The remedy is to void the plea bargain altogether and go back to square one. Case 11. Defendant enters into plea bargain for 4 years in prison, suspended, plus probation. Plea included admission to a 1 year prior. Defendant then violates probation and is sentenced to 4 years. Defendant appeals. During the appeal, SB 136 voids to 1 year prior. Held. Remedy. Reduce sentence to 3 years. Case 12. PC 1170.95 hearing for a 2007 murder conviction. Held. Deputy DA's burden at the hearing is to prove beyond a reasonable doubt that defendant is guilty of what he was convicted of under current law. court is to make its own finding. Simply finding that a jury could convict under the current law is not enough. DCAs are now in conflict. Case 13. Disagreeing with N. Ray A.L., this DCA holds that PC 148 is violated when the defendant knows or reasonably should have known that the person he was resisting is a police officer. To download a PDF of all the summaries added this month, or to download the entire database, please go to our website at casebanklaw.com.